So my first question is about the Domestic Abuse Act, and it's this, which is to what extent does the Domestic Abuse Act, in your view, offer adequate protections to women and girls who have been or may be subject to domestic abuse?
I've always argued that the Domestic Abuse Act won't deliver due to the fact that after 20 years of savage cuts to every part of the justice system and our partner organisations such as the police, the children's services, social services, refuges, court cuts, court closures, we're starting from a sub-zero position in terms of the necessary resources that we need, which are essential if we're going to meet the overwhelming need for these services. There's been a massive rise in domestic abuse cases, as everyone knows, since the start of lockdown, and an increase in domestic homicides. I think one of my main arguments with the Domestic Abuse Act as it is now is that, as one of the CEDAW commissioners put it in 2019, when they were assessing the inquiry into the UK government, it's far more aspirational than achievable. For example, it includes a whole series of new police powers for the Domestic Abuse Protection Notice and Order. In actual fact, they do a little bit more than the old Domestic Abuse PIN, but from my perspective, there is very little point in giving the police more powers when they just don't have the numbers of officers on the ground to properly use their old powers, and they didn't use them. The government has not listened to the advice of the coal-face workers that they've had for years, since the Home Affairs Select Committee on Domestic Abuse in 2008, and before then probably. They've also voted down some of the really important, specific amendments that were sought and granted and agreed in the House of Lords, but then voted down in the House of Commons, such as there will be no serial domestic abuse and stalking register. Urgent amendments that would have protected migrant women and children have now been left out, and so much for no woman left behind, which was what we were promised. The Commons voted down the extension of the discretionary domestic abuse concession for all forms of visas, and they voted down extending the period of support from 3 months to 6 to 8 months. This just means that migrant women are specifically and targetedly left out of the Domestic Abuse Act. I would argue that 3 months isn't long enough for support under the discretionary concession because of Home Office delays. We're seeing visas cancelled by left spouses. We've got no recourse to public funding refuge spaces, so migrant women face being on the streets with their children. In a report by Southall Black Sisters, they reported that social services were telling women to go back to their countries of origin and leave the children with the abusive fathers. And I've personally had social workers telling me that they will take the children into care if a woman is leaving a family situation because of abuse. But they have no duty to the mother at all, so she can do whatever she likes. The government voted down compulsory domestic abuse training for judges, which has been urgently recommended now for over a decade, and was again highlighted in the judgment of the President of the Family Division on the 31st of March of this year in the appeal case of H&N. We're seeing rape at less than 2% in terms of prosecution. In the pilot, which gave legal representation to victims that I was a part of, out of the 30 or so women that I represented, we only achieved a prosecution in one case, and then only after seeking an external review. And there were many cases where there was adequate evidence, and I really welcome the review, which was announced on the 21st of April, that there's going to be a review into how we're dealing with rape cases, because it is an absolute scandal. I'm also very concerned that the most recent Violence Against Women and Girls strategy is proposing a separation of domestic abuse from the VOG strategy. This is against express advice from the sector, and it's also in breach of CEDAW Article 35, which makes it clear that all legal frameworks must start from a position that domestic abuse is a gendered issue and that all forms of violence against women are discrimination. And I think removing domestic abuse from the Vaughan strategy, we lose the holistic approach and the obvious gendered intersectional nature of domestic abuse. So I think there are some, I don't want to write the whole act off. There are some good things about the act. Much of it hasn't come into force yet, and there's an awful lot more to be provided to us by way of specialist guidance from the government. And I think that I'm reserving my final judgment on it. But I think that without a massive, massive injection of resources, it just isn't going to do anything. That's my view.
Thank you. Thank you, Ms. McCurley. Let me move on to what we in the legal profession refer to as Laspo, which is the Legal Aid Sentencing and Punishment of Offenders Act 2012, and to ask you what, in your view, has that act had in ensuring the UK's compliance with its obligations to ensure full enjoyment by women of their human rights and fundamental freedoms without discrimination?
Well, we've now had, since it became a law, we've now had 2 CEDAW inquiries in Geneva, 2013 and 2019, both of which were highly critical of Laspo. It's had a crushing impact on the compliance with Articles 15 and 16, well, with the whole of CEDAW, Articles 15 and 16 in particular, I'll discuss at the moment. It removed from all forms of family law from scope of legal aid unless they were explicitly included. And the one concession that was made was that women who could provide court evidence of physical violence would be able to access legal aid if they were financially eligible. And it has to be said that even the government's own equality impact assessment was clear before CEDAW ever became law, before Laspo ever became law, that women would be disproportionately and seriously badly impacted by the cuts due to women being less financially secure than men, more likely to have caring responsibilities, being part-time work on 0-hour contracts, so no chance of a level playing field, essentially. It also didn't take into account the thousands of consultation responses which pointed this out, and the fact that women and kids would be left in positions of significant harm. It also didn't take into account the very significant trauma which is created by non-physical abuse, and at least the domestic abuse new definition assists with that. But 8 years on, we're still seeing no review of the impact of the legal aid cuts, which was ordered by CEDAW in 2013. And it's specifically a backward step for my client group, the Black and Asian and migrant women that I work with, and their children. Thank you.
And the next question is about the assessing risk of harm to children and parents and law children cases report. Quite a long name for the report, but it's, as you know, referred to as the harm report. I know you're very familiar with that. So are you able to help us by addressing one or more of the key outcomes of that report?
Yeah, I really do commend the report. I think it's been a real ray of hope alongside of the domestic abuse bill and the case of H&N, because it really does feel like the combination of all 3 things together might actually get us to where we need to be. It was a breakthrough. They asked the right people, the people on the front line of what the problems are with domestic abuse and obtaining protection and safeguarding and justice. The first thing was that they highlighted is, I've already mentioned, the chronic lack of support and resources at every part of the system. Remember reading one passage in the report, which was the anonymous voice of a senior member of the judiciary who said, the system is on its knees, we are just not coping. And all of us who are working in the system are well aware of that fact. We're not doing what we need to be doing to safeguard women and children. It recommends a trauma-based approach to domestic abuse cases in the family courts. if there's no trauma-informed approach to cases involving domestic abuse, there's no chance of a fair hearing, and the report's very clear on that. It goes into the research on the brain, which is the damage to the brain caused by trauma and the impact on memory and brain function, which prevents those in recovery from abuse from being able to remember things chronologically, to provide a clear and narrative history with dates and times and so on. And in fact, all of those things that lawyers and specifically judges would call credible evidence. And the lack of ability to be able to do that is often wrongly misinterpreted by judges as somebody lacking in credibility, somebody making it up. There needs to be a level playing field to allow vulnerable witnesses to be able to give their best evidence. And if that means recording the evidence in a pre-recorded fashion, then that's what's going to need to happen. Over the years, I've seen judges make comments like, I didn't like the woman's evidence, she was all over the place, she couldn't give a clear date, she couldn't give a chronology. I much preferred the evidence of the man who was very clear, very confident. You know, and how can there possibly be a fair hearing and equality before the law in those circumstances? We need to level up the playing field. Intersectional vulnerability must be assessed. For example, a woman in fear of being deported without her children is less likely to be able to give evidence, best evidence in her case to protect herself and her children, because the stakes are so much higher. We also need a far better and properly researched understanding of parental alienation. It's becoming a very, very popular defence to domestic abuse to say that the traumatised woman giving her evidence is clearly making it all up just because she wants to alienate the children from their loving father. The only cases of true parental alienation I've ever seen have been as part of the domestic abuse of the mother in most cases. And it is always the mother in my cases because I only act for women and children. Yesterday was the first anniversary of the harm report, and we've seen no changes so far. And I think that's been one of the difficulties, I think, of addressing these issues, because straight after the 2013 inquiry, we got a determination from CEDAW to say that the government must urgently impact the assessment of Laspo on domestic abuse victims. And we're still waiting for that report. We still don't have that report. Yeah, I mean, I think the harm report was probably the best thing that happened to me last year, because when I read it, I just thought, yes, they've got it. They know what we need to do. And it was brilliant. And it kind of helped offset some of the disappointment about the domestic abuse bill and the things that were left out, the women who were left behind.
Thank you.